Honourable Phil Heatley.
Thank you, Mr Chairman. Back by popular demand. I would like to thank the Honourable Damien Connor for bringing this to the House on behalf of his constituents. As I spoke about in the first and second reading speeches, it's very important that we put to bed in this particular issue and the issue around the rates payments in the Tasman district from 2003 through to 2008. And of course the preamble neatly summarises the mistakes, what ought to have happened in council meetings in that period, what actually did happen and where the faults are. So essentially this piece of legislation and preamble talks about the 2003-04 right through to the 2008-09 years, where the council passed rates attached to the annual plan rather than ratifying each rate individually, which needs to be done under the Act, and to set rates before the council had actually adopted the annual plan. That was a second big mistake. This was also in breach of the Local Government Rating Act 2002. The Rating Act provides an avenue for councils to amend incorrectly set rates, but the window for that has now passed. And whether that was because the errors were not picked up quickly or because they were set aside as unimportant or in fact ignored, we don't know. What we do know is that this House reluctantly now needs to pass this retrospective legislation to ensure that what is unlawful in that rate setting is now lawful. So the bill is needed to validate certain rates set incorrectly during that period. Without validation, the council remains vulnerable to legal challenge from ratepayers, and validation is also required to allow the council to recover unpaid rates and penalties for the expenditure which they've undertaken during that period. Mr Speaker, looking at the preamble there, I think by way of example it's worth working through the errors that were made in that 2003-2004 rating year. I'm not going to go through the 04-05 year, 05-06, 06, 07, 07, 08, 08, 09 years, but I think by way of example, the 2003-04 year is a good one to start at and to examine. In that particular year, a special council meeting was undertaken. It was held on the 26th of June 2003, the birthday of many New Zealanders, I'm sure. The Tasman District Council resolved, amongst a whole bunch of things, first of all, that the general rate, including the utilities rate, be adopted as proposed in the Council's draft annual plan. So that was the first thing. They proposed that that general rate be adopted. Secondly, there was this Motueka business rate, which they voted be approved for that particular financial year. There was the Richmond business rate that they wished and they in fact voted to be increased in that particular year, and the council also voted to adopt a community facilities rate. So there you have just 4 actions in that particular year: to adopt a general rate, to approve the Motueka business rate, to increase the Richmond business rate, and to adopt a community facilities rate. And I'm sure they meant well. I'm sure there was some consultation about that. I'm sure there was much debate in the council chambers before they voted. Unfortunately, the funding impact statement provided the rate should be paid by instalments. It set out the penalties and it set out all those rates that the council had proposed. However, the resolutions did not in fact comply with what was Section 23 of the Local Government Rating Act 2002 because they failed in several ways. First of all, they failed to state clearly that the council was setting rates as required by that section. So the motion or the vote on the floor should have relayed the setting of those rates as associated with that section under the Act. Secondly, they failed to refer, Mr. Chairman.
Honourable Phil Heatley.
Mr. Speaker, they failed to refer to all of the rates that were purported to be set when the resolutions only referred to the adoption of some of the rates. So they referred to a few of the rates, not all of them, and they should have individually set out each of the rates that they wished to be set for that financial year. The Council didn't comply with Section 23 of the Act by purporting to set the rates before the Council had resolved to adopt the annual plan. They should have adopted the annual plan, then set the rates, so there was an issue there of order. The Council failed to state the financial year to which the rates applied. A simple thing we might think in hindsight, but they didn't actually state to which year these rates would apply in their resolution. They failed to say that the rates could be paid by instalments. And lastly, they failed to resolve to authorise that penalties be added to the rates if they were not paid by a due date. So I think those are quite simple things the Council overlooked to do. Say what year the rates related to, say that they could be paid in instalments, and actually say that in fact there were penalties that could be added to the rates if they remained unpaid. So here we have it, many years later after the 2003-04 financial year, now reluctantly having to pass legislation because of the oversight of that council at that time. And of course those oversights ran into the 2004-05 financial year, 5-6 financial year, 5-6-7 financial year, 7-8 financial year, and lastly the 8-9 financial year, which we're dealing with this evening. As I say, I won't go forward and explain in detail the errors that were made in those subsequent financial years. Members can be assured that I know what they are, that I know here what they are. I encourage members to read for themselves the preamble in the legislation to get a good understanding and grasp of what those errors were. But what I can say is that the National Party is comfortable with passing this legislation to validate in law what should be lawful. Had it been done properly, had due process been undertaken properly in the council chambers when those motions were passed, were debated, were voted for, and as I say passed, we are going to pass this legislation through the House. It's our intention in the National Party to make what should have been lawful, lawful. We do it reluctantly because it's a retrospective legislation. We understand there are still aggrieved ratepayers in the Tasman district. We know that Damien O'Connor, in a sense, was reluctant also to bring this bill to the House, but we feel that it is the right thing to do. Mr. Speaker, I do support this preamble. I challenge other speakers perhaps go through the 2004-05 year and explain to members, to colleagues, the errors that were made there. Perhaps Damien O'Connor could do that off the cuff for the 05-06 year, 06-07, 07-08 and 08-09 years. I'll leave him to make that choice. But, Mr. Speaker, I've highlighted the difficulties. I've highlighted what are quite simple or difficult errors to make, I should say. You should simply have passed those things by resolution. They weren't, and that's why we're here today.
Eugenie Sage.
Thank you, Mr. Chair. Well, commend Mr. Heatley for his detailed